Ladies and gentlemen, let's dive into malicious prosecution. This is a tort, not a criminal statute. So try to understand the difference between the two, okay? So in your torts class or on the bar exam, this will be a part of the MBEs. Very, very rarely will it be on your written exam, so you won't have to really IRAC this situation. But still, be prepared, memorize these rules, okay? And even if you're someone in society who wants to know what this means, this is some fun facts to learn about. So let's go through elements 1 through 5. So elements 1 through 5 boils down to this. Element number 1 is that the defendant instituted criminal or civil proceedings against the plaintiff. Okay, so institution of criminal proceedings by the defendant, in other words. So the defendant must have filed a lawsuit against you. The defendant must have filed a criminal proceeding against you. Okay, let's say the district attorney in Orange County wants to throw my butt in jail. Okay, he files a criminal proceeding against me, and now I have to go to court and fight it. That is an example of a criminal proceeding. Okay, let's say the law firm across the street that specializes in personal injury wants to sue me for negligence, and I get subpoenaed, and I got to take my butt to court to fight a negligence case. That is an example of a civil proceeding filed against me. Okay, that's element number 1. Pretty simple. Element number 2 is that the proceeding must be terminated in the plaintiff's favor. Okay, as you can see, termination of proceedings in the plaintiff's favor, and only then can the plaintiff file a suit against the defendant for malicious prosecution. Okay, so remember, it must be terminated in the plaintiff's favor. Okay, if it's in the defendant's favor, then too bad. Element number 2 is not satisfied, and there is no suit. Okay. Element number 3, that there must be absence of probable cause by the defendant. So, like I said, absence of probable cause for the prosecution, for the criminal or civil proceeding filed against the plaintiff. Okay, what does that mean? That's basically that the reasonable and prudent person under the attorney's shoes should have known by the facts of the case that the plaintiff was innocent. There are not enough facts here to prosecute this person. And there's not enough facts here, if it's civil, to file a lawsuit against this person. So basically, there wasn't enough facts, and or the person who's filing the suit, like the lawyer in this case, knew that the defendant was innocent, but filed the criminal civil proceedings anyway. Okay? So basically, again, element number 3 is it's a pretty high standard for of an attorney, because they need some type of reason to file a criminal civil proceedings against the plaintiff. Okay? But in this case, there was not any. Therefore, that is how element number 3 can be satisfied, as if there is no factual basis to prosecute or file a suit against the plaintiff. Element number 4 is that there was improper purpose. The keywords here, improper purpose of the suit by the defendant, i.e., there was malice here. There was malice involved. So there was another purpose beyond the goal of achieving justice by the defendant. Example, let's just say that my friend Riley hates my guts. He's like, oh, can't stand that guy, Sam. He's such an a-hole. And then Riley's like, you want to know what? I can't find a suit against Sam, but you want to know what? I'm still going to haul him into court because I hate his guts so much. That's basically an improper purpose against me to file a civil suit against Samuel, right? He must have an actual purpose, a genuine purpose to haul me into court. Therefore, if there's an improper purpose for his suit, then this element is satisfied. Okay, you can't just hate my guts and haul me into court. He must have a pretty good reason why he's going to haul me into court. Or even if a prosecutor in our society ends up trying to lock somebody up without probable cause, like I said earlier, and without a proper purpose, then this element will be satisfied too, because that prosecutor doesn't have a real reason, a genuine reason to file a criminal proceeding against that person. The prosecutor is doing it out of hatred or just out of the fun for it. Okay? That is an example of element number 4 is that the defendant does not have a proper purpose. The defendant has an improper purpose of the suit against the plaintiff before it happens. Basically, it's a requisite mental intent of the lawsuit before it actually occurs. So that must be proven. Okay? Lastly, pretty straightforward, is that there must be damages caused to the plaintiff. And this is the easiest one of them all. Let's just keep it real, okay? You think about lawsuits, criminal or civil, you have to hire an attorney, okay? Even if you are an attorney yourself, you still should hire another attorney to have your back, right? Because 2 minds are better than 1, right? But the only person in society probably suing for malicious prosecution is probably not an attorney, okay? So that person has to hire an attorney, take off of work, show up to court, pay for parking fees. The list goes on and on when it comes down to a lawsuit or a criminal proceeding against that person. Therefore, damages can be awarded to the plaintiff when it comes down to that, because basically the defendant will be liable for lawyer fees, all the fees I just mentioned, right? General damages, special damages. And also, one thing that you should note and keep in mind for this situation is that punitive damages can be awarded in malicious prosecution because it is an intentional scenario where the defendant is trying to come after the plaintiff. Okay? So basically, there's ill will against the plaintiff to do something intentionally wrong to that person. Therefore, punitive damages can be awarded in this case. So, let's walk through this one more time. 5 easy elements. It's not too bad. Like I said, this is more multiple choice than essay. There must be institution of criminal or civil proceedings against the plaintiff. Element number 2, the termination of the proceedings must be in the plaintiff's favor. Okay, that's very critical. And there must be absence of probable cause. So basically, the defendant must have known that, look, I did not have enough facts or basically I didn't have genuine belief that the plaintiff really committed a crime or committed a tort, but I'm going to file the suit anyway. That is an example of absence of probable cause because that person did not really believe that a person was guilty of a crime or a tort. Element number 4 is that there was improper purpose. There was malice involved here. So there must be the requisite mental intent, which is malice. There we go. There's malice involved here. Okay, so before the person filed the criminal or civil proceeding, the defendant must have known that, hey, I don't really have a genuine reason to file this suit against the person. I'm just doing it to do it for an ulterior motive, right? I'm doing it for an improper purpose. I don't have a true reason, a true purpose on why I'm filing this civil suit or this criminal proceeding against the plaintiff. Lastly, as I said, this is very straightforward, is that damages were caused to the plaintiff. And that's the easiest one of them all, right? As I said, lawyer fees, parking fees, taking time off work to show up to court. The list goes on and on. This is, again, general, special, and punitive damages are easily awarded to the plaintiff if 1 through 4 elements here are proven. Okay? So if you have any questions, comment below. And if any requests, always comment below. I'm willing to do anything in my power to help you out and help myself out because I'm going to take the bar very soon and I need to know every little detail about the law in order to do well in the bar exam. So like I said, comment below and I scratch your back, you scratch mine. You have a nice night.